Good morning and welcome to day 3 of the Insolvency and Restructuring Conference. We have two fascinating talks for you this morning. First, Marc Brown will be guiding you through the minefield of cross-border insolvency after Brexit. And then Kirsty White will be discussing directors' disqualification. If you have any questions, please click on the Q&A button at the bottom of the screen. Marc and Kirsty will answer as many as time allows at the end of their talks. Without further ado, here's Marc on Brexit and its impact on cross-border insolvency.
Good morning, everyone. I'll just put up my slides for you. There you are. This morning I'm going to talk about cross-border insolvency, in particular after Brexit. And by way of introduction, where are we? Much of this, of course, is familiar to you, but let's see. The UK officially left the EU at 11 p.m. On the 31st of January 2020. But the withdrawal agreement took effect across the following 12 months. And so during the period of the withdrawal agreement, EU law continued to apply until the end of December 2020. It was as if the UK was still a member state for all intents and purposes, and importantly, for the purposes of the recast regulation on insolvency proceedings. On the 24th of December 2020, so Christmas Eve last year, the UK and the EU agreed what's called the Trade and Cooperation Agreement, and that applies from the 1st of January 2021. However, for our purposes, this agreement does not deal with any insolvency issues, although it dealt with avoiding a hard Brexit for various other industries and sectors. The issue of insolvency proceedings was simply not a part of the Trade and Cooperation Agreement. We're therefore addressing what the changes are from the 1st of January 2021 in the absence of EU rules, most notably the recast regulation being enforced as a European regulation, and in the absence of the Trade and Cooperation Agreement saying anything about insolvency. In particular, we want to look at what about UK insolvencies and their recognition in EU member states. Nice and easy under the recast regulation, whichever country opens main proceedings, being the country where the debtor has its centre of main interests, those main proceedings are then recognised across member states and signatories to the recast regulation. With that gone, what's the situation of recognition of UK insolvencies in the EU? And the flip side to that, what about EU insolvencies? Of course, across the member states, they're going to be recognised as amongst themselves under the recast regulation, but they're not going to be automatically recognised in the UK under that regulation. So how are they to be recognised in the UK in this brave new world? Let me start, however, by saying that England and Wales, and the UK in general, remains an attractive place for restructuring and insolvency, even after Brexit. The fact that we're no longer a EU member state and therefore no longer have the benefit of the recast regulation doesn't mean that people are going to avoid England and Wales as an outlier state with no real benefits from its insolvency and restructuring regime. Quite the opposite. Schemes of arrangement, a peculiarly British insolvency regime, remain extremely attractive, and they're tried and tested and well thought of throughout the world. Not only the schemes of arrangement, but the Corporate Insolvency and Governance Act of 2020 introduced the new restructuring plan. That is well received and maintains the benefits of the insolvency regime in England and Wales. Here we have well-set principles and procedures and a well-respected insolvency regime. And that's backed by experienced courts, experienced insolvency and companies court and high court judges. So they're likely to remain well used, and it's certainly the case in my view that Brexit will not see an avoidance of England and Wales and the wider UK for the purposes of restructuring and insolvency. Particularly important where we have this large change from the regulation, the withdrawal agreement when the regulation continues to apply, and then the stop from the 1st of January 2021, we need to look at the transitional provisions. And these provisions aren't going to be of relevance just for a few days or a few months for the start of this year. We're going to see the transitional provisions being relevant for a significant period to come. And the reason for that will become obvious as I explain. So, officially left on the 31st of January 2020, withdrawal agreement gives rise to a transition period until the 31st of December 2020, where we still effectively functioned as a member state and the EU regulations continue to apply, including the recast regulation. What that means is that the UK will continue to recognise insolvency proceedings commenced in the EU in other EU member states, where main proceedings were commenced on or before 31st of December 2020. So it's not a hard stop on the 1st of January 2021. If main proceedings were commenced in another member state before the 31st of December 2020, then those insolvency proceedings will be automatically recognised in the UK under the recast regulation. And that's the effects of the transitional provisions. That, as I say, means that the recast regulation is going to be hanging around in the UK for a significant period to come. Insolvencies could last for 3-4 years, but as long as they were started before the 31st of December 2020 in a member state where the debtor has its centre of main interests, then we're still in a recast regulation situation. So when you're looking at recognition in the UK, the first thing you need to look at is when were the main proceedings opened, and you're looking at that key date of on or before 31st of December 2020 or after the 1st of January 2021 to see what the applicable regime is. What about the new regulations? Well, the Insolvency Amendment EU Exit Regulations 2019. They were then amended by the Insolvency Amendment EU Exit Regulations 2020, and they provide for the amendment of the recast regulation as it has effect in the law of the United Kingdom as previously undertaken by other acts. So what happens as a result of the exit from the European Union is that all EU regulations are incorporated into domestic UK law, subject to amendments. So the recast regulation becomes a part of domestic law and it's amended by the Insolvency Amendment EU Exit Regulations 2019. The effect of the regulations, as they have effect in the law of the United Kingdom, is that UK courts have jurisdiction to open insolvency proceedings after the end of the transition period, where either the debtor's centre of main interests, or COMI, is in the UK, or the debtor's COMI is in another EU member state and there is an establishment in the UK. So there are some similar principles from the regulation that we can see here. And just like the regulation, and indeed just like UNCTRA, the idea of the debtor's centre of main interests remains key. We now have two particular forms of insolvency under the regulation as it has effect in the United Kingdom. The first is where the COMI is in the UK, and we're calling those COMI proceedings. They are what under the recast regulation were called main proceedings. And we have proceedings where the COMI is in another EU member state, but there's an establishment here in the UK, and we're calling those establishment proceedings. And they are what under the recast regulation would be called secondary proceedings. Now, what's different, or what's important to notice here, is that when the EU regulation had effect directly in the United Kingdom, the EU regulation was the basis for jurisdiction to open insolvency proceedings here in the UK. And it ousted the jurisdiction of the UK courts in respect of other entities across the EU. With the incorporation of the recast regulation as amended into the law of the United Kingdom, what we've done is provided that under these regulations, as they have application in the UK, the court has jurisdiction here under these regulations to open insolvency proceedings, whether they be COMI proceedings or whether they be establishment proceedings. But it expressly notes that the jurisdiction is not exclusive. It sits alongside the existing UK jurisdiction to open insolvency proceedings. Just to take as a very simple example, England and Wales recognises a jurisdiction to open insolvency proceedings in respect of companies where the company is registered in England and Wales. Now, that may also mean that it has its COMI here, so you could have jurisdiction under the regulation to open COMI proceedings, but those two are separate and coextensive jurisdictions of the court to open proceedings. And whereas previously there would have been sole jurisdiction under the recast regulation, what we now have is a multiple series of jurisdictions to open proceedings. You could open it under the regulation as it has effect in the United Kingdom, or under an alternative existing UK jurisdiction. So we're no longer restricted by the regulation. The courts can take a more expansive approach to the companies and individuals and entities over which it exercises insolvency jurisdiction. Whether you want to call that taking back control or not is not something I'll express an opinion on, but I do say that it's a more expansive approach than we were tied to under the regulation. I gave a number of seminars in the number of years running up to Brexit, saying how the UK could deal with Brexit. We postulated different ideas. For example, a different form of bilateral agreement between the EU and the UK as to insolvency proceedings. We talked about the continuation of the recast regulation and how that would make things much more simple, but the downside of it being that the EU could amend the regulation without involving us, as we weren't a member state. And we looked at all the different things that might fall out from Brexit and how we might deal with it. One of those we looked at was a hard Brexit. And how we would deal with the insolvency situation in the event that the EU and the UK simply didn't reach any agreement on insolvency proceedings. And I noted at the time that with the things that were being discussed and their importance between the UK and the EU, that it appeared, to me at least, that insolvency seemed quite far down the scale of importance of things being discussed. Well, it seems that may well have been right, because the Trade and Cooperation Agreement just does not provide for any automatic recognition of insolvency proceedings from the UK in the EU or vice versa. And it's fair to describe it that in respect of insolvency, we have a hard Brexit. So what about recognition then? If we have insolvencies after the transitional period, how are they recognised here in the UK or in the EU? Let's start with UK insolvencies and their recognition in EU member states. Well, under the recast regulation, automatic recognition will generally only occur where insolvency proceedings based on the COMI being in the UK were commenced before the end of the transition period, and simply no automatic recognition thereafter. Say we've got some COMI proceedings here in the UK, and we've got some property or a contract in another member state, and we need the assistance of that other member state to enforce rights there. What do? Well, under the recast regulation, we would go before the court, achieve automatic recognition. The laws of England and Wales would apply, and the court of that member state would apply the laws of insolvency or where main proceedings were opened, and we would go on to seek our relief. Now we cannot have that automatic recognition, and we will therefore need to rely upon the domestic laws of the member state. So if you've got property in France, you will need to know what is the legal position of recognition of foreign legal proceedings in France. And only once you know the answer to that can you go on to see what relief you can gain. And that different question is going to have to be asked for most of the EU member states. So there's certainly a complication of the process of recognition of UK insolvencies in the EU. We do have UNCONTROL, however, the model law on insolvency proceedings, and that provides for a well-recognised system of recognition of insolvency proceedings if the country in question has adopted the UNCONTROL model law. And familiarly with the recast regulation, it has as its basis concepts of the centre of main interest. However, Greece, Poland, Slovenia and Romania are the only member states in the EU, as well as the United Kingdom, that have adopted the model law. So this panacea for resolving these problems doesn't seem to have been heavily adopted amongst the EU member states. Whether or not that's because they mostly rely upon the recast regulation, I don't know. But the question I ask is, as this develops, will more and more EU member states see the benefits of the UNCONTROL model law such that they begin to adopt them? And that may well be what happens in the medium to long term. The flip side of the coin, of course, is EU insolvencies, so insolvencies that have been opened in EU member states as between themselves governed by the recast regulation, and what about their recognition in the EU? So you have an insolvency of main proceedings, say in Germany, and the German insolvency practitioners come to you and say, there's some property in England and Wales, and we want to realise that for the benefits of the main proceedings in Germany. Well, EU office holders of insolvencies in member states where there's COMI or an establishment in that member state can rely upon the model law because the UK has adopted the UNCONTROL model law. It was incorporated or implemented into UK law by the cross-border insolvency regulations, the CBIR. So that is your first port of call for recognition of EU insolvencies. And it gives representatives of foreign insolvency proceedings the right to apply to UK courts for recognition of those insolvencies, and more importantly, for the court to grant relief and assistance for the benefit of those insolvency proceedings. It's right to say that the uncontrolled model law is not as strong as the regulation, because the regulation provides for automatic recognition, whereas under the uncontrolled model law you've got to apply for recognition and then for assistance. But it's still effective as a way to give assistance to EU insolvencies. What about outside of the model law? What about if we don't come within that? Because the UK law has adopted over its history an expansive approach to recognition of foreign insolvency proceedings. It may be that that is a product of the courts and systems of England and Wales being seen as an advantageous place to deal with insolvencies. It could be as a result of financial services in London being quite so expansive, and therefore a number of insolvencies coming through England and Wales, even if the centre of main interest is abroad. There are two alternative routes for recognition in the UK of foreign insolvency proceedings. The first is Section 426 of the Insolvency Act 1986, and that particular provision provides a tool for recognition of insolvency proceedings where those insolvency proceedings are taking place in certain designated countries. And that section gives the court power to give assistance to the insolvency practitioners in those foreign proceedings. First thing to check before you seek to engage Section 426 is the list of designated countries, because it's only those that can apply under Section 426. They are, on the whole, Commonwealth countries and Ireland. And I ask this question, will amendment of Section 426 be forthcoming in the future to add, for example, EU member states or the EU in general to the list of designated countries under Section 426? To me, it seems we will have to wait and see whether the uncontrolled recognition causes any problems with recognition of EU member states insolvencies. If it does, then the addition of EU member states to the list of designated countries could provide a safety valve or relief for that situation. But if the uncontrolled model law turns out to offer us everything that we need in respect of recognition, then it's unlikely that legislators would go down this route. And the second form of recognition over and above uncontrolled is the common law. And the United Kingdom Supreme Court restated and recognised the common law's approach to recognition of foreign law proceedings in the case of Rubin against Eurofinance in 2012. And that basically reviews all the historical case law relating to recognition of foreign proceedings. And the court said that the common law recognises a principle whereby what we should seek to achieve is the court of the debtor's domicile having unitary insolvency proceedings that then receives worldwide recognition and applies universally to the debtor's assets. And that principle was described as the principle of universality. Effectively, what it does is take the ideas of uncontrolled, take the ideas of the recast regulation and say, actually, our common law seeks to apply this across the whole world. We take wherever the debtor's domicile is, and we seek to assist wherever possible to achieve a circumstance whereby there is one insolvency proceedings in the court of the debtor's domicile that is recognised across the world and applies universally to the debtor's assets. Now, of course, the courts of the United Kingdom are not in a position to apply that across the whole world. But what the courts here will do is seek to apply it insofar as they are concerned with worldwide insolvency proceedings. So where does that leave us? What are the practical issues that flow from the brave new world of cross-border insolvency after Brexit? Well, we know now that there's no uniform legal regime for cross-border insolvency. And Europe or the EU member states join the other countries of the world in how they fall to be recognised in the United Kingdom and vice versa. Practically, for insolvency practitioners, it means there's going to be a need to apply local insolvency law to EU member states that are not signatories to the uncontrolled model law. And I'm afraid that looks likely to increase the cost and time involved in obtaining recognition of UK insolvencies in other EU member states. It also means that there may be different approaches in different member states. If you've got a company with its centre of main interests here in the United Kingdom with assets in France and Germany, you cannot be sure that your insolvency will be recognised and or dealt with in the same way in France as it will be in Germany. You're going to have to deal with them separately and depending upon the local insolvency laws, see how that plays out. It does seem to me that there's a greater role for the court to play in applying and potentially expanding the role of universalism. It's a principle that the Supreme Court seems keen to push to demonstrate the UK as a leader in insolvency law, that it takes the view that universalism is what should apply. And we wait to see whether the court will take a more proactive approach in seeking in its interpretation of the new regulations, the uncontrolled model law and so on, to expand and apply the principle of universalism. And finally, as things continue on, more insolvencies fall outside of the transitional provisions and therefore need to be recognised in the EU member states, depending upon how much that happens and how much difficulty that causes. We will have to see whether that leads to more member states adopting uncontrolled. Because if, for example, all member states across the EU were to adopt uncontrolled, then we would have a much more straightforward system of recognition across the EU for UK insolvencies. One word of caution, however, unlike an EU regulation, which must be taken as read in the law of the local country, uncontrolled, when it's adopted, can be amended by the member state when it or if it adopts it. So that will not relieve insolvency practitioners of any obligation to look at the particular form of the uncontrolled model law that's been adopted by the member state in question. So that's my discussion of cross-border insolvency after Brexit, and I'm now going to hand you over to Kirsty White to talk about directors' disqualification.
Thanks, Mark. I shall just share my screen with you if you just bear with me one moment. And okay, so in this session I'm going to start by having a recap of some of the legislation before moving on to look at some of the recent case law. In particular, I'm going to pick out some key points from the Kids Company judgment that was given in late February. And I must say it is like a short novel, being 220 pages long. And then I'm also going to have a look at a recent case challenging disqualification undertakings. So where do we find the rules? The Company Directors Disqualification Act 1986, and it's section 6 in particular that applies to disqualification proceedings that are brought after an insolvency. Disqualification proceedings can be brought against directors at any point. It isn't just after an insolvency, but in the rules in relation to a disqualification after insolvency are found in section 6, as I say. The wording is set out on the slide, and I'm not going to read it out verbatim, but I just want to pick out what the key word is here, and that is in section 1, subsection 1b, and it's this key phrase that the court is looking at conduct that makes the director unfit to be concerned in the management of a company. So whilst a person may be disqualified if they are named as a director, the Act also looks at de facto directors. And the court considers that when it's looking at this as to whether someone is a de facto director, they're looking at whether someone has asserted an influence over a director, and that director has acted in accordance with that person's instruction or directions. And we'll come on in a moment in Kids Company to look at how the court considered that, and ultimately, without giving too much of a spoiler, why the court considered in that case that the CEO wasn't a de facto director. Any proceedings brought under the Company Directors Disqualification Act must be brought within 2 years of the date of the formal insolvency of the company. And insolvency practitioners can use their powers under section 236 of the Insolvency Act to consider if anything has gone wrong. And then they will submit a report about the directors to the Secretary of State if it appears to them that conditions for disqualification are satisfied. That report is submitted via an online portal and needs to be submitted within 6 months of the investigation commencing. I think the court has recognised in case law that insolvency practitioners, when they're looking at whether a director has shown conduct that would make him unfit, they're balancing very difficult decisions. They're considering both legal and commercial decisions of that director, and they're trying to balance those two things up together when they're coming to their conclusions and whether in their report, and also when they're recommending to the Secretary of State as to whether they think that disqualification proceedings should be brought. And again, without wanting to give too much of a spoiler, we'll see how in Kids Company the court considered that that had just fundamentally gone wrong, and the court, the insolvency practitioner and ultimately the Secretary of State and the official receiver hadn't properly considered what they were looking at and the extent of the reports there. So what is the effect of any disqualification under the Act? Section 1 clearly sets out what the effect of this disqualification is. That person is preventing from acting as a director, receiver of company's property, or taking any part in the formation or management of the company without the leave of the court. Also in section 1 it states that anyone who is disqualified will not act as an insolvency practitioner otherwise, as well. I think it's important there to just highlight that this section does relate to the management of a company again, and in my view that's gathering and catching up anyone who's acting as a de facto director. So they may say, well, I'm not actually named as a director, but it's preventing those shadow directors in the background. If a court determines that a director is unfit to hold office, the minimum period of disqualification is 2 years to a maximum of 15 years. And the length of disqualification varies depending on the type of conduct and also the seriousness of the conduct. But the typical length that we tend to see and is imposed for breaches of Companies Act duties, for example, is about 5 years. Now, if an individual is a subject of either an order, disqualification order, or they've given an undertaking, that doesn't mean that they can't apply for leave of the court to act as a director of a particular company, which they would do under Section 17 of the Act. And again, I'll come on to look at that in a bit more detail shortly. Or they can ask for the undertaking or the order to cease under Section 8A of the Act. And again, I'll look at the context of that in case law shortly. So what is the purpose of the legislation? Now, we go back to a very early case after the enactment of this Act. And the philosophy is it's to protect the public against the future conduct of companies by persons whose past records as directors have shown them to be a danger to creditors and others. Now, that principle has expanded over time, and case law has looked at expanding that definition, but it all comes back to the same central point of it's about protection to the public. Its main focus is not a punishment. So what conduct will the court consider? And this is set out in Schedule 1 of the Act. The court shall have regard for any misfeasance or breach of fiduciary duty by the director in relation to a company in England and Wales or an overseas company. Any material breach of any legislation or other obligation that applies to the director, again, either within England and Wales or an overseas company. And it will also look at the frequency of any conduct of the director, which fall into the above two. So, as I said earlier, the frequency of any conduct can affect the length of disqualification. It is an important factor to consider. Okay, so let's have a look at this in the context of a recent case. Now, I'm sure you've all heard of the Keeping Kids Company, more colloquially known as the Kids Company. And as I said, it's an absolutely huge judgment. It's 220 pages long. And I was joking to Mark and Rob before we began this session. I think I read it in 3 sittings with several cups of tea. Mark commented to me, actually, whilst it's a long judgment, the conclusions, and you can see where it's going, are quite evident from the first couple of pages. But what I would say is if you are going to read this judgment, as we all do probably when we get our own cases in, turn to the conclusions, which are at the last sort of 30 pages or so of the judgment, and have a read through there, because it does set out quite clearly why the judge has come to her decision and bringing in factors throughout the other 200 odd pages before it. So it's a good starting point, and also gives you a clear view of how scathing the judge was of the official receiver, and also an indication of how not to bring disqualification proceedings. So I've tried to pull out some key parts of the judgment to talk through. There are many bits I could have pulled out, but just tried to pull out those that I think are key takeaways for today. So just a very brief overview of the facts for anyone not familiar. So Kids Company was a charity. Whilst it was a charity, the trustees were directors and therefore operated in accordance with the Companies Act. So the Disqualification Act applied. The allegation is, as I've set out on the slide, it was one collective allegation made by the official receiver. And essentially it was that the directors had caused or allowed the company to operate an unsustainable business model and had known or should have known that its failure was inevitable. Not very specific, not very focused, not identifying which individual director knew or ought to have known, at what points they knew or ought to have known. And that's quite important because there were 9 directors, I believe, from memory. And it was just this one catch-all allegation of, I think, what we could phrase as incompetence rather than any dishonesty or any attempt to inappropriately gain. The company failed in or around 2016, and that was following the withdrawal of large amounts of funding from private donations. Now, that withdrawal of funding came after there was what turned out to be an unsubstantiated claim of sexual misconduct made against certain persons within the charity. Unfortunately, that allegation was made at a time where, as a country and the world, were learning about the conduct of Jimmy Savile. And so in the backdrop of that and what had come out in relation to Jimmy Savile, the private donations very, very quickly dried up, and the company charity found itself in a position where it didn't have the necessary funds to operate. Now, the company had operated the same business model for 17 years prior to the first date that the official receiver had identified as being a concern. Just taking from the judgments and as the judgment took from the official receiver report, the model was a demand-led model of self-referral for clients, the children who would attend centres or the services provided by the charity, and it had a policy of never turning a child away. As I said, the charity was dependent upon large ad hoc grants, donations and loans to meet its expenditure, without any sufficient reserves being maintained or any other provisions for the eventuality of the grants, donations or other loans drying up. So it didn't maintain any reserves at all to meet its outgoing expenditure. The official receiver identified a date in September 2013 in which it said that the directors should have been aware that the business model was then unsustainable. The judge in her judgment said, well, actually, I don't really think that's a date you can identify because the charity, the company, it didn't fail for another 2 or 3 years after that point. And given that the company charity had operated this business model for 17 years, it didn't point to a suggestion that the company model was inherently unsustainable at all. The official receiver pursued the named directors, and it also pursued the CEO. She wasn't a director of the company, a named director of the company, but they pursued her on the basis that she was a de facto director. And as I set out a few moments ago, when the court is looking at whether a de facto director, or sorry, whether someone has in fact acted as a de facto director and therefore should face disqualification, they're looking at whether a level of control or a level of direction has been given by that person that the directors have ultimately followed. So what did the court decide in this case? I've given a few spoilers, that the court was less than impressed with the manner in which the official receiver conducted itself, and the way in fact it actually presented the case. If I deal with the CEO first, the court held that she was not a de facto director and therefore should not face any disqualification order. Now, as I said, we're looking at whether the de facto director has influenced the named directors, and in this case that just simply wasn't the case. The CEO actually reported to the trustees and directors, and they were the ones who gave her the direction. yes, she may have made some decisions in the day-to-day running, but ultimately she was bound by those powers that were put upon her by the trustees and the articles of association and the manner in which the company operated. The judge felt that the official receiver just hadn't properly considered the idea of de facto director at all. And she wasn't particularly pleased with the manner in which the official receiver presented its case against the CEO. And if you read the judgment, you will see exactly how unhappy she was. And turning to the second finding, that the official receiver had failed to establish that the trustees were operating an unsustainable business model, and neither were they unfit, warranting disqualification. Now, the first point that the judge took issue with, and I'm sure many of you sort of scratched your head when you saw on the previous slide how the allegation was put. It was a single allegation. It was very broad. It was not substantiated in accordance with requirements against each director, naming Director A. They would have known at this point in time, or they would have known that this aspect of the business model was unsustainable, and that differed from Director B for the following reasons. That simply just wasn't the case. And neither did the official receiver consider each director separately, as they should have done. So I think if I just pause there and give what the takeaway is from that finding, if you've got 2 or 3 directors in a company, it's really important that when you're considering your report and your investigation, the specific conduct of each director, don't lump them all together and say, well, they all must have known. Be very particular, come to conclusions about each director, and consider whether you do have enough then to push on for a disqualification order or ask for an undertaking. And conversely, if you're on the other side of that and you're advising the directors, consider, has the case been properly set out against you, and you, the director as an individual, or all the directors being lumped together as they were here. Now, moving on slightly, the judge had some considerable difficulty, as I've again given away slightly in some of the earlier comments, that she just had a difficulty considering the official receiver's position with regard to the business model. But as the case developed, what became clear was it was less about the model and more about how it operated from 2013 onwards. It was this idea that the trustees had done too little too late to address the model and how they controlled expenditure and cutting costs. So actually, as the case developed, the advocates for the official receiver developed the case and said, well, actually, what we're more concerned about is there were warning flags and warning signs, but nobody thought to then start keeping some reserves to make sure we could meet, the company could meet expenditure in the future. But the judge didn't make any finding on that, because the official receiver's complaint was that the trustees were aware the model was bound to fail. And the judge felt that the official receiver had failed to demonstrate that idea, the model was bound to fail. And what she did say as well was that she wasn't very impressed with the manner in which the official receiver presented its case, and particularly with how it had interacted with the directors. They'd been faced with this massive, overarching general allegation about the model being unsustainable. And what the judge said was, well, as your case became clearer and you were actually saying that you should have operated in a different way, you should have moved away from that model, that's not the case you presented to the directors, That's not the case that the report that was given to the directors demonstrated, and therefore the directors simply didn't have an idea of what the case was that they were meeting. It was only through the course of trial did that become clear. So again, if I just pause there and give the key takeaway, in this case, the reports were very, very lengthy, and in parts the judge found were biased. So the points that the judge made in the judgment were that actually the report should be very focused, and they would be focused if you thought about the manner in which you wanted to present this case, but that simply didn't happen. And as a result, there was unfair prejudice essentially to the directors, as they simply didn't understand the case that they were having to meet until it was advocated at trial. Considering whether the directors had acted with reasonable care and skill under section 174 of the Companies Act, now there was a slightly different focus because these were charity directors rather than directors of a company, so slightly more leniency was placed here, but the judge did not consider that the trustees' decision making fell outside the band of reasonable responses available to them. She didn't think that the trustees had acted unreasonably when they considered the clients over the creditors, but she said it was an error of judgment, but it was not such a high degree of incompetence so as to justify a finding of unfitness. So again, the takeaway here, when you're considering, do you want to press on with directors' disqualification orders, properly consider that that behaviour, those decision-making processes. As I said at the start of this presentation, insolvency practitioners are weighing up legal factors and commercial factors. And here it seems that the judge felt that this was a commercial decision that was just not the best, if I can put it that way. Could have been made in a better way, but it wasn't incompetent. Anyone could have made that error of judgment, essentially. So I think there's a lot to be learned from the Keeping Kids Company judgment. As I say, if you're considering any disqualification proceedings, it's worth going to the final sort of 30 pages of the judgment, having a read through, thinking about how you might want to structure any reports, structure how you want to think about how you put any allegations and how you put the proceedings, and make sure they are tight, not generalised, specific to each individual director, and just make sure you don't fall foul of the same mistakes. Okay, so just to come full circle, I mentioned at the start we'd spend a few minutes looking at how a director might challenge a disqualification. And Section 8 deals with if there is an order, and Section 8A is in respect of whether there's an undertaking. Now I'm going to have a very brief look at the case of Ahmed and Secretary of State for Business Enterprise and Industrial Strategy. And this is a recent case of Marc Brown's, so I'm sure he'll jump in and correct me if I get anything wrong, but hopefully not. So just a very brief overview of the facts here. This is actually an appeal regarding application under the Company Directors Disqualification Act. And the director, Mr. Ahmed, had given an undertaking that he would not act as a director, and he wanted leave of the court to act as a director for a particular company. So he made an application under Section 17 of the Act, but he also wanted the disqualification undertaking should cease to be in force, so made an application under Section 8A. At first instance, the court gave him leave under Section 17 to act as a director for a particular company, but it didn't grant him leave, it didn't grant him his application under Section 8A. Now, on appeal, Mr. Ahmed challenged the finding under Section 8A and said that he wanted the court to consider the application afresh and for the undertaking to cease to be in force. Now, the undertaking was due to expire in May 2021 anyway. The court on appeal did say, well, you've been given leave to be a director for a specific company, but I appreciate actually you may want to be a director of a number of companies in that period. What the court did on appeal was it reviewed the case law in this area in relation to Section 8A. And it noted that in order for a undertaking to cease to have effect, then the court would need to consider whether there are any special circumstances that would allow the court to exercise its discretion. Now, the court considered, in line with the case law, that those special circumstances could be that the factual basis of the undertaking was incorrect, or the undertaking was given on the basis of a misrepresentation or a mistake, or even if the original basis for the undertaking is not impugned, then the applicant seeks relief on the basis of circumstances that might have subsequently arisen that were not intended to be covered by the undertaking or could not have been foreseen at the time of the undertaking. Now, at the time the undertaking was given, Mr. Ahmed was suffering from substance abuse and various mental illnesses. And since that date, he had received treatments for both substance abuse and also his mental illnesses. And he felt that this then gave him a different circumstance, and therefore his application should be considered under Section 8A. What the court said on appeal was that actually, yes, okay, the judge at first instance did fail to properly consider Section 8A, but the outcome would be no different. The court felt that the treatments and the progress that Mr. Ahmed had made didn't actually fall into one of those special categories. Now, the court commented that the purpose of the director's disqualification rules is to be a rehabilitative process of an offending director. And in this case, what was being presented was the fact that a director had rehabilitated himself, but that doesn't give rise to a special circumstance. And therefore, the court was not minded to give the application sought under Section 8A, and said in any event that Mr. Ahmed had been given permission to act for that particular company under Section 17 of the Company Directors Disqualification Act. Mark, I hope that's a good overview of the case there, but I don't know if there was anything you wanted to add, given that it was your case.
Yeah, it was an interesting case. I can't say that I agree with the appeal court judge. It was a case where the applicant had been disqualified, and there was medical evidence to show that the offending behaviour had been caused by his alcohol abuse and substance abuse. and there was it could not be known at the time that he gave the undertaking whether or not he would successfully recover, because for those types of maladies, just having treatment by itself is neither here nor there. What actually demonstrates recovery is a period of time. So there was the medical evidence to show that in fact he had been in recovery for a very significant period of time. And so the case was about the effect of rehabilitation on shortening the length of disqualification, and we sought to draw the distinction between a director who does nothing to rehabilitate him or herself and would be in exactly the same position. But the judge said that, well done, you've rehabilitated yourself, and that's to be applauded, but that's what was expected of you. So you've done what you should have done. You haven't gone above and beyond. Yeah,
she wasn't quite that forthcoming with that information in the judgment. So it's always good to have the advocate to give you a bit more of an insight.
Yeah, absolutely. Yeah, that's it. Right.
Well, thank you both very mu't for two fascinating talks. I'm not going to let you off the hook quite yet. Mark, can I ask you this? Going back for a moment to Brexit, cross-border insolvency, you described the jurisdictional thresholds for opening insolvency proceedings in England as being quite wide, giving the example of a court opening proceedings because a company is registered in England and Wales. Do you think that a court might refuse to grant a winding up order, administration order, in its discretion because of a lack of real connection with England, in the same ways that in the old days it might refuse to make a bankruptcy order based on mere presence in the country?
Absolutely. We are more expansive than just looking at the regulation, but nonetheless, there does need to be some reason why the UK court would exercise its jurisdiction, either because Comey's here, Comey somewhere else, but an establishment here, domicile here, some connection with the jurisdiction. And the court is not going to exercise its insolvency jurisdiction over a company or individual that simply has no link with this jurisdiction at all.
Thank you. One more question. I should say it was rather refreshing having heard a number of your talks speculating about what would come after Brexit, to hear you talk about what the law is after Brexit. But I'm going to take you back to speculation, because you described this as a hard Brexit so far as insolvency goes. Are the current rules for recognising EU proceedings in the UK and vice versa a long-term solution or a stopgap?
It depends how they work out. If we don't have any problems, if it actually works out that this gives everybody everything they need, Uncontrol here seems to work okay, and we can identify what we need to do in different member states, and everybody works towards the common goal, then this could be the long-term solution. I don't see such insurmountable problems that we couldn't live with this if we needed to, unless it creates any real difficulties, I doubt there will be a very powerful lobby to change things. But that doesn't mean to say we couldn't make things easier. And for my view, what would I like to see? I'd like to see this as a stopgap towards EU member states adopting Uncontrol, because that would give everybody a more straightforward approach of universalism across the EU. But without it causing a problem, I don't see the appetite for it.
Watch the space. Kirsty, interesting to hear about the Keeping Kids Company judgment. Do you think that there's still room for disqualifying for incompetency rather than for dishonesty or breach of another duty?
The judge didn't entirely shut the door on it in the judgment, and I think it comes down to this idea of reasonable responses under Section 174 of the Companies Act. So is the incompetency, the behaviour so bad that actually it's not something that a reasonable director would have come to, that decision. So yeah, I do think there is still some scope for it.
But extreme cases, perhaps.
Yes, absolutely.
Super. Well, thank you both for your fascinating talks. Thank you, everybody, for listening today. We hope that you will join us for the 2 remaining sessions of this conference. Tomorrow, Ali Tabari will talk about light touch administrations and everything else new in the administration world. And Raghav Trivedi will bring you up to date on directors' liability cases. And then the bit I'm looking forward to most, on Friday, we're going to bring you together with us, with all the members of the Insolvency and Restructuring team here, to discuss topical issues and to answer your questions. And this will be an informal session with an opportunity for all of you to participate. I hope you can join us for both of those sessions.